You can be questioned under legal compulsion, under the penalty of 5 years in prison, for 24 hours, released and prohibited by law from disclosing that any of it ever happened. A few months ago, I showed you how Australia's proposed hate speech laws could make what you say at work, in a private group chat or in your own home, a criminal offence. And a lot of you asked, well, how far can this actually go? What I'm about to show you makes those laws look like child's play, because the hate speech laws tell you what you cannot say. And what I'm going to show you now is what happens to people around you. Under Australian law, right now, weeks away from becoming permanent, an intelligence agency can compel your husband, your wife, your children, your parents to sit in a room and answer every question put to them about you, about what you said, about who you know. They don't have to be suspected of anything. They don't have to have done anything wrong. And if they refuse, 5 years in jail. And they can't tell a single person it's happening, including you. That agency is ASIO. Those powers have existed since 2003. And a bill that has already passed through the House of Representatives is now before the Senate, expected to be voted on within weeks. That would make these laws permanent and expand them into exactly the territory that the hate speech debate was always about. And in the next few minutes, I'm going to show you how these two frameworks connect, what that combination actually means for you and me, for ordinary Australians, and why this is happening right now, while almost no one is watching. To understand what's changing, you need to understand where these powers came from, because the way they were created tells you everything about why removing their safeguards matters. September 11, 2001. The Howard government moved quickly, as governments around the world did, to expand the reach of their domestic intelligence agencies. One of the most controversial proposals was this: give ASIO the power to compel anyone to answer questions. Not suspects, not people charged with anything, anyone with information that they wanted. The bill took 15 months of parliamentary debate before it could pass, because it was genuinely contested. Labor's opposition was fierce. One backbencher from the inner west of Sydney argued that forcing people to speak to an intelligence agency without judicial approval was the kind of power you expected from authoritarian governments, not Australia. He drew those comparisons publicly on the floor of Parliament. That backbencher was none other than Anthony Albanese, who is now, of course, Prime Minister, and his government introduced the bill to make those same powers permanent. Now, I want to be clear about what this tells us, because it's not a political point. The coalition has supported this bill too. It's bipartisan. What it is a structural observation about how extraordinary powers behave over time. The politicians who most fiercely believed these powers were dangerous when they were in opposition became, when in government, the politicians most comfortable making them permanent. And that is a pattern worth understanding, and I'll come back to it. Labor eventually let the original bill pass in 2003, but on one condition: a sunset clause. A sunset clause is a legal mechanism that would cause the powers to automatically expire unless Parliament voted publicly and deliberately to renew them. A democratic circuit breaker. It was written into the law as an acknowledgement that these powers were extraordinary, exceptional, temporary by design. Parliament extended them in 2006, again in 2014, again in 2018, again in 2019, again in 2020. 6 extensions over 22 years. And now, rather than seek a 7th extension, the government has decided to make them permanent. So let's look past the politics and examine what these powers actually do and who they can be used against. The gap between what most Australians believe their rights are and what the law actually provides them is significant. Here's what the statute says. Under this Act, the Director General of ASIO can apply for what's called a questioning warrant, but not from a court, not from a judge, from the Attorney General, a politician. Once that warrant is issued, the Australian Federal Police can physically apprehend you and bring you in for questioning. Now, and this is the part that I want you to focus on, you do not have to be a suspect. You do not have to have been charged with anything. You don't have to have done anything wrong. You simply have to be someone ASIO believes might have information relevant to national security. You can be questioned up to a cumulative 24 hours. Adults, 8 hours at a time. before a break is required. Children, because this applies to children as young as 14. No more than 2 hours at a time. And here's what happens if you don't answer. Under subsection 34GD3 of the Act, forgive me, but if you want to look at it, you may as well know where it is. I'll put it in the comments. It is a criminal offence to refuse to give information, a criminal offence to fail to appear, to not turn up, a criminal offence to provide false answers, and the penalty for each of those is up to 5 years in prison. Your lawyer can be present, but only with ASIO's approval, with restrictions on what they can advise you on. And this one deserves a moment on its own. It's a criminal offence to tell anyone that you have been questioned by ASIO. You must be silent. Not your partner, not your employer, not a friend. You can be questioned under legal compulsion, under the penalty of 5 years in prison, for 24 hours, released and prohibited by law from disclosing that any of it ever happened. So let's put this into a real-world scenario, because this is way easier to understand when it's a person, not a provision. Imagine you run a small community organisation. 3 years ago, you attended a conference and you met a foreign diplomat. All right, hear me out. It's possible. These things happen. You've had no contact since. None in 3 years. But ASIO has developed an interest recently in that diplomat. And you have information they want. You're not a suspect. You may not even know that ASIO is aware of you. But under this law, as it exists right now before any amendment, a warrant can be issued. The federal police can turn up to your workplace and you can be brought in. And you're not allowed to tell your workplace why. You're questioned. You're required to answer the questions. And if you say nothing, 5 years. If you call your partner that evening and tell them that something's come up, you're going to have to tell them that you can't explain what that something is, because that disclosure is potentially a criminal offence. Your lawyer, present, if ASIO approves, restricted in what they can tell you, that's the law as it stands today, before any expansion. So this bill passed the House of Representatives in February of 2026. It is now before the Senate. When the Senate votes, which is expected within weeks, the bill becomes law. Now, it does 3 things. First, and this is the centerpiece, it removes the sunset clause permanently. So the powers that Parliament agreed in 2003 were exceptional and temporary will become a permanent standing feature of Australian law. Second, it expands the scope of who can be questioned. This bill expands compulsory questioning to cover all 7 of ASIO's areas of security and responsibility. So these additions are sabotage, threats to Australia's defence system, threats to border integrity, and one I need you to pay particular attention to, promotion of communal violence. So how is this relevant? Well, the hate speech framework and the ASIO expansion are not identical, but they are operating on exactly the same terrain. The hate speech laws ask whether your speech constitutes an offence, whether the groups you associate with make you a criminal. ASIO's questioning powers ask whether your speech, your association, or your online activities are relevant to that. So here is what that combination looks like in practice. A person argues publicly at a community meeting or a protest or an online forum about a contentious social issue. The argument becomes heated. They almost always become heated. But ASIO forms a view that this activity touches what the new legislation calls promotion of communal violence. So that person is brought in and they are required to answer. But so are the people around them, their partner who was at the meeting, their adult child who shared the post, their younger child who lives in the house and hears the conversations around the dinner table, their parent who may have replied to it. None of them are suspects. None of them have been charged with anything. They simply have information that ASIO wants. All required to answer every question, and they are all prohibited from telling anyone. And if any one of them refuses, there is a potential they could go to jail for 5 years. The record matters here, and I think it's been misread. I'm not saying that ASIO has misused these powers. The record doesn't support that. In 22 years, 20 warrants have been sought and issued. The powers have been used quite sparingly. So why does a sunset clause matter if the powers are rarely used? Because a sunset clause isn't primarily about how often the powers are used. It's about accountability. Every few years, someone in Parliament has had to stand up publicly and justify these extraordinary powers to the Australian community. The debate itself was the mechanism of protection. But when you remove that friction, the powers stop being exceptional. They become background law. They become normal. And the normalisation is not a feature, it's a risk. So the government says that this is about keeping Australia safe, and I'll give them this. The threat environment is real. But I want to leave you with one question. These powers don't require a court. They require a politician's signature. And they apply not just to suspects, but to anyone with information deemed relevant to security. So this is the question. If you were brought in tomorrow, not because you'd done anything wrong, but because you knew someone or attended something, wrote something, published something, what rights would you think you had? Now you know what the law actually says. I'm James Glissan. I'm continuing to do breakdowns on all of the laws that are coming in, the ones that we have, the rights that you do have, and the ones that you don't, but you think you do. I've been speaking with Mark Bouris about the Ben Roberts-Smith case. There's been a lot happening. But if you want your question to be answered, if you have a burning desire to understand something in the legal system that isn't clear, subscribe and leave it in the comments. And I will see you in the next one.